5 seconds. It is to be noted at this juncture that the issue involved in this writ petition has already been considered by the Punjab and Haryana High Court in the case of Capro Power Limited versus State of Haryana and others in CWP number 29437 of 2017 and the Division Bench of Punjab and Haryana High Court by its order dated 28/3/2018 rejected the very same contentions raised by the respondents therein and observed that the provisions of Section 8 of http www.judis.nic.in the CST Act Rule 12 of the CST R&T Rules and Declaration of C form have not undergone any amendment after the implementation of the GST laws, and therefore there cannot be any usage of C form only for the purposes of resale of the 6 items mentioned in the amended definition of goods in the section 2D of the CST Act. The Division Bench further observed that Section 7 does not stipulate that only a dealer liable to pay tax under the sale tax law of the appropriate state in respect of any particular goods is entitled to apply for registration, nor application for registration can be made or C form can be issued only in respect of the sale of the same goods prescribed in the course of an interstate sale. The division bench also found that the registration certificate given to the petitioner therein under the CST Act has not been cancelled. In those circumstances, the Division Bench of Public and Haryana High Court allowed the said writ petition and held that the respondents therein are liable to issue C forms in respect of natural gas purchased by the petitioner therein from oil companies in Gujarat and used in the generation or distribution of electricity at its power plants in Haryana. The relevant findings made in the above said case reads as follows. The above said decision of the Punjab and Haryana High Court was put to challenge before the apex court by the state of Punjab and Haryana in state of Haryana and ORS versus Capro Power Limited and ORS in the petition for special leave to appeal C number 20572 2018. The Honorable Supreme Court dismissed the said SLP on 1308 2018 after hearing both sides by especially observing that there is no legal and valid ground for interfering with the said order made in Capro Power Limited case. Therefore, it is evident that the said order passed by the Punjab and Haryana High Court in Capro Power Limited case having been confirmed by the apex court as stated supra is binding on the respondents herein as well as, and therefore they are not entitled to take a different stand and contest the matter before this court. It is to be noted further that Apart from Punjab and Haryana High Court, the other high courts have also considered the same issue and have fallen in line with the findings rendered in the Capro Power Limited's case. The following are the decisions rendered by the others high courts. The above decision of various high courts, more particularly the order passed by Punjab and Haryana High Court made in Capro Power Limited's case, confirmed by the Honorable Supreme Court, would show that the respondents herein are not entitled to take a different stand, especially when the facts and circumstances in all these cases before this court as well as before the other high courts as extracted supra are one and the same. In other words, the issue involved in these cases as well as the cases before the other high courts is one of the same, out of which one decision was confirmed by the apex court as well. Therefore, I find that the impugned communications, apart from being without jurisdiction, are not suitable also on the reasons and finding rendered by the Punjab http www.judis.nic.in and Haryana High Court on the same issue confirmed by the apex court.